Supreme Court ending cash bail for people arrested in Illinois. Starting September 18th, judges can no longer require people charged with a crime to pay money to leave jail while awaiting trial. Instead, judges can only keep someone behind bars if they are considered a flight risk or a threat to public safety. Joining me now to break this all down, DuPage County State's Attorney Bob Berlin. Mr. Berlin, thank you for your time.
Sure. Good morning, Brad. Good to be here.
Yeah, we appreciate having you. First, it's a confounding bill. It's long, it's convoluted to me, the layperson, and controversial. You were against the original draft, we'll call it, if you will. In the least confusing way, what is the Safety Act now, and why should the viewer at home care?
Safety Act now is the amendment that was passed in December of 2022, and it's significantly different than what the original Safety Act was. The two biggest changes are the dangerousness standard. The original Safety Act, under the dangerousness standard, judges would have to find that a defendant was a threat to a specific named person, and the state would have to name that person in the petition, which will be very difficult to prove in many cases. Now, the judges can detain someone if they're a threat to the community. So it's a much broader and easier standard for the state to prove. The second biggest change in the amendment was the legislature greatly expanded the number and types of cases where judges have the ability to detain individuals if they're a threat to the community. That includes all forcible felonies with the exception of one, that being burglary, and many other felonies were added to that amendment.
So you cried foul at first, and it sounds like you got some pretty tectonic changes. You voiced concerns with the bill when it first came out. Then you were invited to serve on a panel with other states' attorneys to sort of rectify the wrongs in that bill. You talked about some of the changes you pushed for. Did you get all of them, or does it still fall short per your estimation?
We got most of the changes that we asked for. Unfortunately, no, we did not get all of them. And what we were really pushing for was a New Jersey model. New Jersey, which eliminated cash bail in 2017, allows judges to detain defendants in any criminal case if they find that they're a threat to the community, a threat to flee, or a threat to intimidate witnesses or jurors. The bill that was passed in December 2022 gives judges discretion in most cases, but not all. There are still categories of offenses that judges will not have the ability to detain defendants. And that, in my opinion, is still a deficiency in the law that needs to be fixed.
Okay, State's Attorney Bob Berlin, some people are calling this an experiment, but it's not too novel. New York got rid of bail for nonviolent felonies and misdemeanors back in 2019. As you mentioned, it was some time ago in New Jersey. Voters there, actual voters, approved an amendment to essentially end cash bail. The exception being if a judge deems the defendant at risk or not showing up at court. So is it novel, or do you feel like we've got enough of a blueprint from elsewhere to make this more palatable?
I think Illinois' law falls somewhere in between what New York did and what New Jersey did. So no, it's not novel. Cash bail has been eliminated in other places. And frankly, in New Jersey, if you talk to judges, prosecutors, and criminal defense attorneys, they all agree that that law has worked very well. When New York eliminated cash bail, they took away the dangerousness standard, and judges could not detain on a dangerousness standard. And that's why you saw a huge increase in violent crime. So we're hopeful that moving forward, we can change the law and move more towards a New Jersey model where judges have discretion in all criminal cases, because every case is different, every defendant is different. And the whole idea is we want to protect the community. And if someone is a danger to the community, judges should have the ability to hold that person pending trial.
Right, like you said, just as an example, under what was affirmed by the Supreme Court. In no way can someone who is accused of felony burglary, that's one of those exceptions to that. So that's obviously, and you could say there are some burglars accused of that who are deemed dangerous. So moving on though, eliminating, do I have that right, Dal?
It's correct.
Okay.
Residential burglary is detainable under dangerousness standard, but not burglary.
Okay. And eliminating cash bail has been politicized, of course, on both sides of the aisle. Politicians have been accused of trying to score points with voters because it's such a hot-button issue. Has there been fear-mongering surrounding this bill, painting its passage as a free pass for criminals? And conversely, is this an all-encompassing solution to the state's flawed criminal justice system? It's kind of being sold at polar ends. Where do you see it falling?
Look, our goal in criticizing the law initially was never about politics. It was always about public safety. Our number one concern is public safety and protecting victims of crime. And that's why state's attorneys across the state raised the issue of the problems with the law. And it caused the General Assembly to go back in a session in December and create this trailer bill, which in my opinion significantly changed the law. So that was always our motive. It was never about politics. It was always about public safety. And Brad, as I said earlier, we got about 85% of what I think needs to be in the law. It's certainly significantly better, but there's still more work that I believe needs to be done.
Okay, so on that end, Illinois Supreme Court ruled ending cash bail constitutional. Does the buck stop there, or do you see it going to the High Court, the U.S. Supreme Court?
No, I think this is the end of the line. I do not see a way to get this into federal court. It's really a state court issue. It's a state law. And I think that the state's attorneys across the state of Illinois accept the ruling. Many disagree with it, but they accept it. We are prepared to move forward. And I can tell you in DuPage County, we have been prepared. We will be filing petitions to detain on those defendants that we believe should be detained, and we will continue to do everything we can to protect the community.
Before you go, bottom line, will the SAFETY Act make the public you're sworn to protect less safe?
I think that remains to be seen. We don't know how it's actually going to play out, how it's going to be implemented. It does rely on judges to make these decisions, something I've been pushing for. So it's very, very important that we have quality judges making these decisions. And I'm confident, at least in DuPage County, that that is going to happen.
Bob Berlin, longtime voice for victims, state's attorney for DuPage County. Thank you for your time. We appreciate it.
Thank you very much, Brad.